everyone, this is Abe from ESM. Today I'm going to be discussing Governor Newsom's executive order from May 6 related to COVID-19. Today's discussion will be workers' comp oriented. I'm going to be discussing how this executive order changes things, what types of COVID-19 claims are going to be compensable or considered covered under workers' comp, who is covered, what an employer's responsibilities are, what should an employer do to manage these types of claims, and how will this affect workers' comp premiums moving forward. So a little bit of history. On March 19th, we all know that the initial Governor Newsom's executive order was for shelter in place. The May 6th order creates a rebuttable presumption that COVID-19 claims are compensable under workers' comp. I know that may be tricky for some of you that haven't heard of those types of terms before, so I'll discuss those in further detail, as well as what a presumptive case is. It's really broadly applied, so it applies to any worker who is directed to work outside of their home, not just essential workers. So for example, I'm working remotely right now, and I'm one of the few that would be actually excluded. I haven't been back to work since shelter in place in person at the office. If I were to be directed to go into the office next week, for example, and I tested positive for COVID-19 within 14 days of that afterward, obviously, that would be a presumptive case if it fell within this window. Order's in effect till July 5th, so that's really important. There's a shortened window for when this is in effect. However, there is some legislation coming down the pipeline that may make this more permanent. What that looks like, we're not sure yet. There's some bills pending, and I won't get in those too much yet. We'll keep you updated with any developments on that front. So with regard to COVID-19, the date of exposure must be between 3/19 and 7/5 in order to have this presumption. One of two things has to happen. You either have to have a positive test or a diagnosis of COVID-19. Now, if you have a positive diagnosis, you actually have to supplement that with a test, but you have an additional 30 days to present that positive test or wait till the test results get back, whatever the case may be. And all of that has to occur within 14 days of performing work at the place of employment. Again, not if somebody's just strictly working from home without any coworkers. So some of the elements of the executive order, really some of these are unprecedented. They've shortened the window for carriers to 30 days, effective 5/6, to investigate these types of claims. That's opposed to the normal 90-day window that they give to insurance carriers in order to evaluate whether something is compensable or work-related. Another issue is going to be for temporary disability. It's not automatic. They're also waiving the waiting period. Some of you may know that the waiting period in California is 3 days. So it takes 3 days before that temporary disability starts accumulating. Without getting into too many details about it, that portion is going to be waived. However, all sick leave and benefits have to be used before temporary disability is due. So this is where communication with the carrier will come into play, making sure that you understand what types of sick leave we're talking about here. It's not the normal sick leave that people accumulate just by generally working. Obviously, that doesn't apply to normal work comp claims as well as these types of claims. We're talking about the sick leave specifically targeted to COVID-19 under the Families First Coronavirus Response Act. TD also must be recertified every 15 days rather than the normal 45 days. What that means is with a normal claim, so to speak, you'll see work status updates around every 45 days or so, and usually the adjuster will reach out to you and see if you can accommodate those work restrictions. COVID-19 cases, they need to recertify every 15 days, and ostensibly that's so that they're not taking protracted time off. Maybe they're asymptomatic and they're able to return a little bit quicker, and also to make sure that they're getting the care that they need. So what does rebuttable mean? Really, I talked about how an employee establishes a presumptive case. They fall within the window, they have a positive test, for example, and it's within 14 days of them working there. It's presumed work-related. That burden then shifts over to the employer to show that it didn't actually occur at work, which is, of course, a high bar. It's like, as I mentioned, proving something like the flu didn't occur at work when you're around a lot of other coworkers and other people in the office have it. There's obviously evidence that may prove otherwise, or perhaps they tested positive previously. There's a variety of ways that might play out, but it's going to be obviously case by case. So once the burden is shifted over to the employer, they can rebut that with other evidence. They can rebut that presumption that it actually occurred at work. Maybe their wife had it previously, or their spouse, and they had come into work subsequently and it was their first day back on the job. Who knows? Some things that you can control in this are going to be some of the responsibilities. Now, with regard to reporting these types of claims, it's really important to reach out to the carrier to see what their guidance is. A lot of carriers are just having you report any types of COVID-19 activity, providing a DWC-1. I would be on the safe side in handing those types of claim forms out. Now, there's no necessary heightened duty to hand these types of forms out per the order. Usually that standard's pretty high. It's not just a sneaking suspicion. It's something that they're affirmatively saying, I have a work-related injury. With these, with a presumption, it implies a different type of standard. And this should get clarified if any of this becomes codified into law. Time will tell, but I would be on the safe side because there's such a shortened window to investigate. I would be giving all the information I have to the insurance carrier, filing your claims timely, and having them adjust it and take a look at it with their lawyers and their adjusters that will be trained to look at these types of issues and compensability concerns. And that really goes along with staying in touch with your claims examiners, making sure that they have accurate information, making sure that there is no delay for benefits, that they're getting everything that they need, and also investigating those cases that may be questionable to you and highlighting those red flags that you can bring to their attention. It's also important, really communication is key in workers' comp in general, but you can imagine if you're an employee and you're diagnosed with COVID-19, you get a positive test back, they may not be aware of what their rights are to file a claim, or they may be concerned with their livelihood. They may be concerned about their health. They may be concerned about spreading it to coworkers or their family. So you really want to put yourself in their shoes and provide that support, give them the information that they need, allow them to file a claim if it's something that they're not a remote employee and they potentially could have caught it at work. So you can discuss all those options with them, let them know that you're in contact with the carrier, let them know about the family's first benefits. Those are things that you can control as an employer during this case. It's also important to keep a separate log of all COVID-19 claims that are submitted to the carrier. The WCRB proposed unanimously and approved unanimously, in fact, to exclude these types of claims from the ExMod. ExMod is kind of like your credit score for determining your workers' comp premium. It's still pending approval as of this recording from Commissioner Laura. That vote should take place on July 1st, but I'd be really surprised if it doesn't pass. It's still going to be important either way to make sure you're keeping a log of all those types of claims. Going along with that, you'll also want to keep just good records in general. People that are working from home during this time, obviously, if they haven't worked within the last 14 days, at a specific job site that they allege to have gotten COVID-19. Well, that's going to be material information that you want to be able to provide to the insurance carrier. So keeping track of who's working from home, keeping track of that payroll will be really important. WCRB also has a proposal that they approved, and it's pending approval from Commissioner Laura again, for salary continuation to be excluded for work comp premiums, as well as changing the payroll class code for people that are just working from home. So there's a bunch of different elements there. You don't have to memorize, all the different elements of even a compensable claim or a presumptive case. Really, this is just to familiarize yourself with it. Once you have this kind of documentation, you can hand it over to either your broker or the insurance carrier and have them walk you through it. We're seeing a lot of reopenings. Obviously, as that occurs, there's going to be a lot of different reopening requirements, different stages. I won't get into this too much because it could be a totally separate webinar, but the resources are there. Governor Newsom has his reopening requirements, for example, performing a detailed risk assessment and implementing a site-specific protection program, disinfecting protocols, social distancing. All of that is changing day by day. Certain things are obviously going to be in there no matter what while we're working through the pandemic, but make sure you're checking those resources so that you're in compliance and you're up to date on all the reopening requirements as you're bringing employees back. We obviously have been working on COVID-19, our compliance center, since day one. So we've given webinars and we have training, really everything that you need for reopening, exposure control, remote work employees, returning them to work. So you don't have to reinvent the wheel. We have all the information and resources available for you. Just check it out at esm.com. The link is right on the slide there. I mentioned a few proposed bills in the legislature. I'm not going to go over these just because we're not sure which ones will actually become law. There's actually, as of this recording, there's more than just the ones I'm showing here, but they're varying rebuttable presumptions for certain types of workers, hospital employees, really to make this type of thing permanent moving forward so that they're not just treated like another type of claim. With that, I will sign off. As always, feel free to reach out and utilize our resources if you have any questions. Thank you for your time.